Hello, everybody. Uh, Thank you very much for being here. So today we have another one of our Global Intellectual Property and Technology Center lecture, GIP Tech lectures, and and we are super honored and very happy to have Professor Kretschmer coming in and discuss with us one of the hottest topic that is out there, that of platform regulation. As you know, I mean, multiple legislative frameworks are about to be updated or have been updated in this very domain. Professor Kretschmer is one of the major figures in the field, and he's been director of CREATE for about 10 years now, a center, one of the major center in Europe and worldwide for the study of everything that is IP and technology related. And I think that you celebrated the 10th anniversary of CREATE this very year, and now they are launching re-engineer, create with more funding in order to do more research. But the research they've been doing under the lead of Professor Kretschmer in the past 10 years really shaped the legal environment in the field as it is. Of course, Professor Kretschmer is based at Glasgow University. I should have mentioned that to you, but I think you know that already. And without further ado, I don't want to take up any of the precious time that you can share with him. He's going to present a very fascinating topic today, ruled by codes, which of course makes reference to the codes of practice that basically are ruling our online life, our own life, as Floridi calls that. But I also think that this is a joke making reference to the other codes, which are the algorithmic one, which are very pervasive in our life. And then the other codes, the code of practice and power, that governance now done by artificial intelligence of our own life. So the floor is yours. Thank you so much for being here. Traveling also these days around Northern Ireland is not easy with the storms and whatever is happening. So thank you so much for being here. Please.
Well, thank you very much. Flattering introduction. I won't be able to meet those expectations at all. Thanks for coming. And for giving me a generous time to speak about codes. As you very eloquently explained already, codes have got multiple ways of interpreting the allusion, but I see them as codes of conduct or code of practice as a kind of emerging regulatory paradigm which we haven't really thought through. There are big questions of rule of law behind a regulatory mechanism which is based on something which is quite opaque, and hopefully we at the end of today we have a bit more clarity about what we actually might want to find out, whether this works as an approach to the big questions of digital regulation. So I started to think about codes about kind of 2 years ago as part of another study, and I picked it up that they turn up everywhere as a form of co-regulation. I mean, they've been around for a long time as a form of regulation. In competition law, we had behavioral remedies. In professional bodies, we've got codes of practices for nurses and so on. So it's not that codes are something new, but as a regulatory paradigm, they are. And my kind of suspicion turned out to be right, because they're really popping up everywhere. And just from hot topic of the moment in EU AI regulation. So the consolidated text from the political agreement was leaked this week, and for the first time we can actually see how the general purpose AI and let's say the GPT panic has translated into a legal text. So for a long time it was a question whether there were kind of a subcategory of high risk what type of obligations would be attached specifically to large language models. So the solution they come up with, unsurprisingly, again, is something we will have to talk about again later. And you see in the way this is scoped out in the text already some of the key, conceptual issues with codes. So are there self-regulation? Are there co-regulation? What's the role of the executive? And you see here, for example, that there is basically an expectation of self-regulation. So the AI operators have to come up with a way of meeting certain obligations in a formalized way. But if they don't do it, then we have got the executive, which will be the AI office or the commission, telling them what to do. But we don't really know on which basis they do this. And if you look at the categorization, how you fall into a firm that will have to be regulated under these rules, the systemic risk criteria are, very hard to operationalize in law. So actual or reasonably foreseeable negative effects on fundamental rights or society, you don't want to leave that to a decision of the executive. That's a dangerous kind of route. So you see already here, a lot of the issues that we may have to think through more carefully. Okay, so I see codes as part of a big paradigm shift. So if we looked at technology policy at the beginning of the kind of web age in the 1990s, the idea was we do ex post regulation. So liability arises once you acquire knowledge, and then you have to act. So sometimes, you will know this kind of slogan, the 26 words that created the internet. So unless there would have been this liability safe harbor, the internet would not have gotten off the ground. That's one view. So if providers had been liable for the content that's posted onto them, they wouldn't have been able to innovate with the range of services. And copyright law is the area of law which took this kind of approach the most seriously and formalized it. And in some ways, it traveled from the US into the e-commerce directive. E-commerce directive is now is still there. It has slightly different additions in the DSA. Again, we come back to that. But you have basically the general principle of technology policy, let innovation happen. And if something illegal turns up, you have to act. But we're moving now to something else. We're moving to what I call here special status and ex-ante obligations for strategic platform firms. And now we have to also include AI operators. So essentially, you have to anticipate what might go wrong. It's not that if something goes wrong, you have to act. And these type of ex-ante kind of obligations turn up in all the digital instruments. They turn up in competition law. They turn up in the in more content focused interventions, and they mirror each other. So very interestingly, the UK's kind of interventions are. I would say they almost track what the EU is doing. And in this big picture, IP has a very different role than it has in the past. So if you look in the past, content moderation, takedown interventions after notification, copyright by far is the dominant form of unlawful activity that is regulated. So there are 5 billion requests. It's a 2021 number. Far exceeds all other forms of content intervention. So copyright law was at the center, I assume, of the first paradigm. In the new paradigm, IP law is basically subsumed in a much wider kind of sweep. So the first half of my talk, I will go through a socio-legal empirical study about the emergence of the field of platform regulation in the UK, where we kind of track how this kind of paradigm change from ex post to ex ante, how that happened in a specific traditional setting. So I take you through this, some of this quite quickly, but it gives you a flavor for how one might investigate this. So the baseline for that study are 8 reports issued by official bodies in the UK in an 18-month period. And the idea was, there was a new parliament, the issue of online harms became part of the public agenda. And the idea was basically to track through official bodies using a sociological methodology of issue attention cycle. So interventions in law happen once they reach a level of attention that requires a reaction. So we tracked the harms which are mentioned in each of these reports to see how they would generate responses. So the method is laid out here in 7 steps. I don't need to go through all of those in detail, but so what's the problem that's stated in need of solution? So that's where the harm concept comes in. What are the legal domains under which they may be solved? Which are the agencies that may address it? How do the agencies relate to each other? What are the statutory basis for these agencies? There we already come into the big question I raised at the beginning. And also, how do we kind of conceive the object which is supposed to be regulated? So quickly through the first one, I will basically rattle this through because part of the effect of this is basically seeing how much there is, in the end, we arrive at more than 80 harms. So society at this moment in time, in these 18 months, was concerned, well, I wouldn't call it a moral panic, but there's clearly, a deep unease about what's going on online. And the concerns range really from child protection to terrorism and security to misinformation. That, in each report that there's different issues are foregrounded. And very interestingly, as you progress, there's the distinction emerging between content that is illegal and content that we don't like, which trouble us, but where there is no clear basis on which it is forbidden. You get the feel. There's plenty of things which people are disturbed about. Okay, so as a next step, we then use the same data set of the text of these reports to code them by legal sector domain under which interventions or solutions to these societal issues were conceived. The dominant ones are data issues and competition issues, which surface in every single report. And for our IP colleagues, maybe worryingly, IP is no longer the at the top of the societal concern. So then we identified the agencies and also try to identify the network position of the agencies vis-a-vis each other, how they are cross-referenced. And the 9 most cited agencies are here. So that's from the advertising standards to film classification, data ethics, CMA, that's Zero, that's the counterterrorism unit, which is part of the Metropolitan Police, but we know very little about how that operates. ICO, data, Outcome, Internet Watch Foundation is offers kind of lists of child pornography, and the IP office. So these are the 9, and this is how they're distributed across the reports. And again, we have got slightly differently than the issue. Ofcom and CMA, the Competition Authority, are kind of central in the network. And in some ways, we also see that in the reality now, if you look at who has a regulatory center stage in the new regime, for the online Safety Act, we have Ofcom, and for the digital market consumer bill, it's CMA, the Digital Markets Unit. Here you've got the size of the regulators and where they sit. Again, I don't spend time on this, it's not the topic today. And here we look at the statutory underpinnings and the powers these agencies have. So are they advisory? Have they got investigatory powers? Have they got enforcement powers? Have they got a statutory underpinning? Who do they report to? And again, the analysis more or less links you to the regulatory regime which is emerging. And now we look at the levers. So which are the tools which the reports cite as the mechanism by which solutions may be possible, and there are a wide range, but the codes are turning up in multiple places. So this is really more of a fun end. So we coded all the firms mentioned in these 8 reports, and turns out that there's no UK headquartered firm mentioned at all. So the whole regulatory kind of effort really is focused on US multilateral companies, which again is, I think, interesting for how we conceive this kind of regulatory shift from ex post to ex ante, because in many ways it links also to state sovereignty and legitimacy. Okay, so now we come to codes. So codes turn up as a potential tool in many of these reports, and if you look at the legislation, we will go to that in a minute, they turn up everywhere as well. They're sometimes called differently, sometimes they're called of conduct, sometimes they're called of practice, sometimes they're behavioral. If you're more in the competition law field, there will be behavioral obligations, there may be transparency obligations or unbundling obligations of that type, which could be imposed ex ante, before actually something bad happens. The attraction of codes in a fast-moving technology is quite intuitive. Codes, you don't have to run through a long legislative procedure. They have various levels of consultation, but they can be adjusted as the world change. However, we know very little about, for example, how to abandon them. We don't know under what kind of conditions they are enforced. And the private parties become kind of centerpiece to how law is made. In practice, it is a form of law. but it is exercised in the extreme through the terms of service of the major companies. So the way the law operates on you as a person in a society is through the terms on which you enter a platform. So essentially, it's fusing private rule-making and public rule-making. And I think that's a very useful way of thinking about this. Okay, so now I'm starting to, what I gave you up to now is kind of a work-through study. Now it becomes a little bit more exploratory. So in this new study, we're trying to track, how codes operate. And as a first step, we try to just look at the UK, what kind of codes are actually in operation, and how did they come about? In which year did they, where they started? Do they have a statutory underpinning? I haven't got time to go through that, but you can see there's an acceleration. There's an acceleration of codes, but they range, from anti-discrimination, employment law issues to supply of supermarkets, which are more kind of traditional kind of competition concerns, to Internet Watch Foundation takedown codes, to search codes for copyright infringement. There's a whole range of different types of interventions. So I give you a few examples first from the IP field to give you a feel for how these codes may have functioned in the past. So how a well-known one is the terms of trade under the 2003 Communications Act. So here Ofcom essentially approve a code of practice by the public service broadcasters about the retention of IP rights. So up to that intervention, essentially the commissioning broadcasters acquired the IP rights from the producers of programs. After the code, they were retained by the producers, which enabled them to exploit them internationally. Which led to a complete transformation of the broadcasting industries in the UK, because suddenly you would have independent broadcast production firms making large amounts of money from the US market, from the European markets, and but it had also paradoxical effects. I don't need to go through there. In that there was then a subsequent consolidation of the independent production sector, basically, because they now had valuable assets. It made sense to buy them. But what is interesting that it worked as a code. Okay, so why it's not clear, how it could be enforced. The obligation in the terms of trade is that public broadcasters have to submit a code of practice. But if Ofcom wasn't happy with it, or if they failed to submit, it wasn't clear what the remedy would be. Here's another one related to the IP field. So that's the code of practice relating to search and copyright. So this was a successor to the graduate response, which in the UK was never implemented. It was in the Digital Economy Act, but not translated into an actual process. So it was replaced by essentially, the IP office getting the search engines in a room with the big right holders and agreeing on some kind of rules of deprioritizing infringing content results from search terms. Interesting enough, we know nothing about the effectiveness of this code at all. So there's no public information. We don't know how they've done it. We don't know how they measure effectiveness. So, and it contrasts quite sharply with what we know about the terms of trade of the television producers. Here we've got another one that's a new one. Again, I picked the IP ones because they are in some ways a good starting point for people from our discipline to think about it. So the bargaining codes, so again, we've got an example where we had an IP intervention, exclusive rights for press publishers through the Copyright and Digital Single Market Directive, which didn't really translate into licensing agreements of the type the press publishers wanted. And Australia came up with a different solution to the same problem, which is a bargaining code. Essentially, the code says, again, you go in the same room, you have to negotiate. If you can't agree, there will be arbitration. So a different kind of model. So there's some kind of enforcement end built in, which we haven't seen in the other ones. So now we come to the DSA, and I believe there's some DSA aficionados in the room. So the DSA makes vague references to self and co-regulatory agreements. So they can become part of, I assume, systemic risk mitigation. So if companies agree a code, then they can be seen to be in compliance with a risk mitigation mechanism. There's also some more specific provisions relating to online advertising. And a first example of a code of practice that has been incorporated in the DSA operationalization is the disinformation code. So the disinformation code was a classic self-regulatory scheme prior to the DSA. Basically, there was appeal from the executive, we need to do something about disinformation. If we don't do something, we may have to legislate. That's how it often works. So then the people go in the self-groups in the same room, and they agreed on some kind of principles, voluntary principles, how content on platforms is treated. And these principles were then incorporated in the terms of service of those who signed up to the scheme. And I mean, they all sound very sensible. Though if you are on any of the social media, you will see that we are quite far from having them implemented. Yeah, I wondered, any of our DSA experts have views on the disinformation code? So famously, Twitter initially was reluctant, then it signed up to some commitments, and last year, Elon Musk basically said, "Oh, it's nothing to do with us, no longer part of the process." And interestingly enough, he basically withdrew at the time when it was incorporated formally into the DSA as a risk mitigation mechanism. And when companies agree to have it incorporated in the DSA, suddenly the enforcement of the DSA comes in, which is massive. There's a potential 6% fine, 6% of global turnover. But if you don't agree that this is your compliance mechanism, there's nothing the Commission can do. So we're in a really peculiar situation that basically, Twitter says, okay, we don't do this, we don't do this. But basically, the only thing the Commission can say is, you need to come up with your own risk mitigation measure. If you don't do that, then you're in breach of DSA obligations. But that means that these carefully worked out rules about disinformation, are essentially not enforceable. Okay, now online safety bill and codes of practice. So there has been a lot of change. And the act is actually a lot better than the bill was. So what you see here is from the bill some of the issues which were particularly concerning. And so the underlying idea of the online safety bill is that there's a duty of care on providers of regulatory services, which are user-to-user and search services. And And for the regulated services, Ofcom, the communications regulator, issues codes of practice. So, and they've started the process of consulting what these codes of practice should be. But essentially, it is, you know, what needs to be in their terms of service. So they will include aspects, for example, of what you have as a disinformation code in the EU. So these will have to be part of the rules under which every user interacts with their social media. But in the initial drafting, the obligations extended, you know, not only to illegal content, but also to harmful content, which was unspecified. Nor was the role of the Secretary of State solved. So in the initial draft, I have that here. The Secretary of State had powers of direction. Essentially, if they didn't like what Ofcom was negotiating, they could instruct them. But the executive essentially could change the law, which is really, from a rule of law perspective, pretty disturbing. So this is how it turned out in what we have in front of us in the moment. It's a very complex piece of legislation, 300 pages, and good luck to anybody who is teaching it. But what is interesting is that the codes are absolutely central to what they're trying to do to translate what is a kind of open duty of care into actual rules which change behavior. Okay, so we're getting closer. So the UK AI regulation. So the EU, the UK decided we are kind of staying broadly off AI regulation, apart from safety aspects, which are kind of a little bit well, they echo what the US is doing with the executive orders. We'll see how this works out in the UK. But the code of practice, which is being floated, relates to copyright law. So while the UK is not adopting the kind of product safety anticipatory risk approach of the EU, it suggests a code of practice approach about the nature of the training data. And again, we'll be familiar to what you've seen before. The approach was, you know, the big tech platforms were put in the same room with the IP right holders, and they were supposed to come up with the way which allows the use of you know, copyright materials as training data under some kind of license arrangement. Unsurprisingly, you know, nothing came out of it up to now. So the deadlines were not met, and there is very poor documentation of what here has been negotiated. Okay, so this is where I am at the moment with this project. Having looked through, you know, what is coming as a wave of different kind of measures with different underpinnings. I think these are a range of questions under which we could kind of catalog how these codes actually work and should be conceptualized as a part of law. So the first question is, you know, who? So how do you come within the scope of a code? Because a lot of these new measures, you know, whether they're strategic market status firms, for example, or you know, high risk services. There is some executive discretion or some regulatory discretion whether you come within scope. You know, for the EU, typically there's a quantitative threshold. They try to get numbers of users or, you know, computing power. If you reach a certain number, then you become, you know, caught by the obligations, which then have to translate in the code of practice. But in the UK, we don't have that. Typically UK. Yeah, so the digital markets unit in the future may say, you are strategic market status firm. Similarly, high risk, who is a very high risk firm under the Online Safety Act? Again, the Ofcom only says they will publish a list, but they haven't given any quantitative criteria. So that may be a good thing or maybe a bad thing. It may well be that we, for some of the big questions of, for example, predatory mergers, for example, where big companies trying to basically buy small innovators to rule out to get rid of potential competition. It may well be that this ex-ante approach needs to have something which cannot be translated into a quantitative threshold. But it's certainly something we need to understand and know. Why do we need thresholds? How do we construct thresholds for coming into scope of behavioral obligations? Then the second is obvious. That's the core of what rulemaking is. So what are the duties? What are the behavioral obligations that are in the codes? The third one is, who is the regulator? So who checks whether the rules are being followed, or who sets the rules? Safeguards, that's a key element. And again, that's I find in most of the codes I looked at, there's very little. In some of the European ones, it's starting to come. But how can you challenge decisions made under a code? So if under a code, your content has been removed, how can you challenge this? Or as a firm, if a regulator imposes a code on you, how can that be challenged? Enforcement, there's a range of different options. The most common one is, are fines. In the UK, there's some movements towards director liability. That's again something I think we need to take very seriously. Transparency, transparency comes in different ways. So in the DSA, we have got access for vetted researchers to the rulemaking of the platform firms, the gatekeepers, as well in the DMA. So there are ways in which you can lift the lid on the basis and the implementation of these rules. And lastly, can they be revoked? So how do you end a code? In practice, most of the time they just disappear. Okay, they're never revoked. They're just no longer kind of followed. But if they become a dominant mode of regulation for the digital field, we need to think about that. Okay, so I think that's the core of what I wanted to say today. So here are some of the papers in that context we have worked on for the last 2-3 years. I haven't really published anything on the code itself, the code project that needs to happen pretty soon. Thank you.